No.
There is no declaration. The declaration is based on a construction. It says that the form is incorrect, the assets form is not incorrect, you've left out this paragraph, you've done this, that's all there is that they discover. And then they build it on that. They say, because this is omitted, you are not a mean. That's the declaration in every case.
But we are, your lordships and your ladyship are here precisely to see whether that's right or not.
No, so that's a separate.
That's not
here to see, but to be assisted by you.
Mr. Uzair, that's a separate basket of questions here. Then whether at all in any of these cases so far till date, is there a declaration looking straight into your eyes saying you're not honest because of the following issues? No, it's not. Nobody's saying that. One is just building, and that's what Samuel Baloch also says. You'll have to construe from the facts, and you say that you're not honest.
My lord, इसीलिए मैंने कहा था कि वो आप मुझे page 6 पे ले गए मेरे notes के. If I had gone through pages 2, 3 and 4, maybe I would have been able to make some submissions on that. My lord, I am very clear that merely because somebody finds that I haven't dotted all I's and crossed all T's in my nomination form, I am dishonest. I am not saying that is correct. That's wrong. That's wrong.
Then in that case, Mr. Uzair, there is no declaration ever so far in any case.
But the point is, what is the declaration to the contrary by a court of law that 62(1)(f) contemplates? Where does that come from? And that's, I will make some submissions on that. For me, that's a formal process that has to be followed. It's not something that the RO can do. It's not something that the election tribunal hearing appeals against acceptance and rejection of nomination papers.
Or a constitutional court?
Constitutional court can do it. There is your lordship's judgment in 2010.
There could be mistakes made, but the question is,
my lord, that is not a mistake. That's a conscious judgment by my lord, and I rely on it.
I'm not noting anything.
My lord, so what I'm saying is, my lord, my submission was that for me the way out is provided by the logic, the rationale of Samuel Baloch itself. Samuel Baloch is deficient because it doesn't follow through with the consequences of its own logic. For example, so that's the problem. And if that gap can be filled, then there is no need to overrule Samuel Baloch. Samuel Baloch is a judgment of...
On that point, that's why you want to take it forward. You said the Samuel Baloch gives an answer in paragraph 6 that there should be repentance, but it doesn't talk about it.
It touches upon
it. And I asked you that how do we follow through? Then you say no, there is no declaration. So please tell us, the declaration is just the way it is. When does the repentance kick in, and how do you bring that in?
There are two stages. First, there will be a declaration by a court. There will be a declaration by the court, and that declaration would be for the purposes of 62(1)(f). One problem with Samuel Baloch is that it doesn't really deal with what court, what proceedings, what nature of dispute would lead to this declaration.
Mr. Bhandari, in paragraph 36 of the Samuel, there is a word declaratory judgment. The declaratory judgment, what is the declaratory judgment? By the civil court or the high court or the Supreme Court?
My lord, it is, and I heard submissions on that also, my own submission, and I'm guided by my lord's judgment in 2010 Lahore. This is not a declaration in terms of section 42 specific relief act. It's a constitutional declaration. It is not shackled by the constraints of section 42 specific relief act. It is, and this is not the first time that the constitution has provided for it. Kindly look at article 181.
How to give the declaratory judgment unless you examine and cross-examine and produce, allow to production of evidence?
Absolutely.
How you can reach to the declaration?
That has to be done. It can't be done without that.
But आप कहते हैं कि अगर वो deficiencies, if we give any detail of those deficiencies, वो पूरी कर ले तो फिर वो ठीक है लाइफ पे?
नहीं, मैं तो कह रहा हूँ वो लाइफ बैन है ही नहीं, वो लाइफ बैन है ही नहीं, क्योंकि अगर आप रिपेंटेंस कर ले, अलाउ मी टू सबमिट माय लॉर्ड। और समीउल बलोच ने ये डिस्कस किया है कि कॉन्स्टिट्यूशन में और भी सिचुएशंस हैं जहां डिस्क्वालिफिकेशन कोर्ट की जजमेंट से फ्लो कर रही है, और कहा है कि जी वहां भी यही है कि जब तक वो कोर्ट की जजमेंट इफेक्टिव रहेगी तब तक डिस्क्वालिफिकेशन रहेगी। फॉर एग्जांपल 63(1)(a 63(1)(b तो 63 जब कोर्ट की डिक्लेरेशन सेक्शन 45 मेंटल हेल्थ ऑर्डिनेंस का कहता है कि अगर कोई पहले डिक्लेयर हुआ है एज मेंटली डिसेबल्ड, अगर वो ठीक हो जाता है तो कोर्ट अपने ऑर्डर वापस ले सकती है, तो वो डिस्क्वालिफिकेशन खत्म हो गई। सेक्शन 63(1)(b अनडिस्चार्ज इंसॉल्वेंट को डिस्क्वालीफाई करता है, बट सेक्शन 41 ऑफ द इंसॉल्वेंसी एक्ट
आगे बढ़े
जी वो डिस्चार्ज का प्रोविजन देते हैं। बट आपके साथ इन रिस्पॉन्स टू माय लॉर्ड्स क्वेश्चन काइंडली सी आर्टिकल 184(1) and 2. Article 184(1) says the Supreme Court shall, to the exclusion of every other court, have original jurisdiction.
उसके लिए है ना declaratory judgment. It is with regard to the provinces and the federation.
Yes, but kindly read 184(2). In exercise of the jurisdiction conferred on it by clause 1, the Supreme Court shall pronounce declaratory judgments only. So this is a declaration created by the Constitution. This is not subject to any law. No law is required, nor can any law change this. This is a declaratory relief, a remedy created by the Constitution itself. And by definition, my lord, the declaration envisaged by 62(1)(f) cannot be given under section 42 unless you expand section 42. For example, it says,
but this declaratory judgment is only in the context of clause 1 of
के लिए है, तो के लिए है।
अगर आपका आर्ग्यूमेंट चले, हम आगे नहीं, एक सेकंड ठहरिए ना, आपने 184(2) का एग्जांपल दिया, तो आइन खुद तयन कर रहा है कि सुप्रीम कोर्ट डिक्लेरेटरी जजमेंट दे सकती है। जरा ठहरिए ना, 62(1)(f) में आइन ये नहीं कह रहा है, 62 में लिख रहा है कोर्ट ऑफ लॉ, या तो आप कहें वो इम्प्लाइड है सुप्रीम कोर्ट एक्टिंग अंडर 184, इधर लिखने में क्या दुश्वारी थी?
मैं अर्ज कर देता हूँ,
ये तो सारी चीजें फिर अदालत ने की है ना, आइन ने तो नहीं की है।
अग्री। लेट मी जस्ट एक्सप्लेन कि मैं क्या कह रहा हूँ। पहली बात मैं ये कह रहा हूँ, क्योंकि ये आर्ग्यू भी हुआ कि जी ये, और आपने भी सवाल पूछा कि ये क्या डिक्लेरेटरी जजमेंट है। मैं ये कह रहा हूँ कि जी ये जो डिक्लेरेटरी जजमेंट्स का कॉन्सेप्ट कॉन्स्टिट्यूशन में है, ये सेक्शन 42 वाला नहीं है।
ठीक तो ठीक, यहाँ भी लिख देते
नहीं सर, वो इसके अंदर है, मैं आप अर्ज कर देता हूँ।
स्पेसिफिक है मिस्टर भंडारी।
सब्सक्राइब करें और बेल दबाएं ताकि कोई खबर रह न जाए।